Hello, my name is Shilpa Mehta, and I am a lawyer with the Feldstein Family Law Group. Today, I will be talking to you about the issue of spousal support in situations where the recipient spouse has been sponsored to Ontario. With this video blog, I want to make you aware of the very serious responsibilities you are taking on if you sponsor a spouse to come to Canada from another country. This has implications for spousal support and child support. When sponsoring a spouse from another country, the sponsor must agree to provide the sponsored spouse his or her basic requirements, including food, clothing, shelter, fuel, utilities, household supplies, personal requirements, and other goods and services, including dental care, eye care, and other health needs not provided by public health care. That's a big commitment. In essence, the sponsor has assumed responsibility to provide sufficient money, goods, or services for the sponsored spouse to live in Canada. And that's not all. The latter obligation continues until the last day of the 3 years following the day on which the sponsored spouse became a permanent resident of Canada. Should the sponsor fail to provide the sponsored spouse with the promised necessities and he or she is forced to rely on social assistance, the sponsor will be required to reimburse the Canadian government for any assistance received by their partner. Matters that fall into the category of a short marriage involving an immigration sponsorship agreement raise some distinctive issues under the Without Child Support formula for the Spousal Support Advisory Guidelines, or the SAGs. These are cases where a marriage breaks down while a sponsorship agreement is in place. In some cases involving very short marriages, courts have used the duration of the sponsorship agreement as the appropriate time period for which spousal support should be payable. In other words, 3 years. As well, in such cases, some courts have also ordered support in an amount beyond the high end of the range to generate an amount of support that will meet the recipient's basic needs and ensure that the recipient is not forced to resort to social assistance. While the Canadian government's main concern is that the recipient spouse not rely on government dollars to sustain him or herself, there exists case law which suggests that social assistance is irrelevant to the determination of support, where there is no indication that the sponsored spouse may need government assistance. Essentially, where a sponsored spouse has been able to attain employment, the SAGs should again be consulted to determine the appropriate range of spousal support. As the SAGs are not legislated, it is very important that the parties consult with a lawyer to determine the appropriate support provisions. But in cases where the recipient has been sponsored, it is even more crucial to seek legal advice, as there is a plethora of corollary issues that must be considered to determine the fair amount of support payable. And often, the SAGs offer no guidance in this regard. If you would like to learn more about this or any other family law topic, please visit our website at www.separation.ca. If you need legal advice about your own situation, please call us at 905-431-2214 to schedule an initial consultation. Thank you for watching.